Welcome to LexTalk World Talk Show presented by Clickway Creators. Today we have Mr. Felipe Martínez Sánchez with us. He's an IP lawyer from Colombia and has more than 7 years of experience in IP matters, mainly in trademark, unfair competition, protection of consumer rights, and litigation in all the said areas. He has worked at multiple Colombian law firms, advising and representing the interest of important national and international companies, primarily in intellectual property and competition law matters. Thank you so much for taking out time and joining us today.
Thank you. Hi, everyone. It's my pleasure being here. Thank you for having me.
We really appreciate it. So, before we get started, can you give us a brief introduction for our viewers?
Of course, I'm a passionate lawyer for the IP and competition matters with multiple years of professional experience at the top Colombian firms in such areas. From the very beginning of my studies, when I was completing the Bachelor of Laws program at the Universidad del Rosario here in Bogota, I felt most fascinated by the private law issues, and that is why I decided to emphasize my practice in such matters. As a result, I received a recognition from my university for completing the optional deepening program in commercial law. Furthermore, my interest in commercial and economic matters never ceased since once I ended my Bachelor of Laws program, I did a specialization in competition law at the Pontificia Universidad Javeriana, which has enabled me to gain a lot of knowledge on national and worldwide regulations and precedents on affairs related to free competition, such as restrictive practices, mergers, and unfair competition. Now, with respect to my professional experience, I have the opportunity to work and learn from the very best and most recognized law practitioners in IP and competition law in Colombia. Currently, I work as an associate attorney at the competition law department of Ibarra Abogados, and I lead the IP department, which is growing day by day. As regards to the academic stage, I have also written some articles, such as the impact of the tax reform in industrial property and competition and football to all acquaintances, which analyzes significant decisions issued in the Colombian legal system and have been published in a highly renowned specialized newspaper in Colombia. Also, I have been selected as panelist in academic events that tend to analyze the present and binary relation between advertising, IP, and unfair competition, and in trainers for companies as regards to competition law and compliance programs.
Thank you for the great introduction. So, you have been working with multiple sections and especially in the intellectual property. So, my next question is how legal sector, especially in IP and competition antitrust law, consumer protection law, and litigation in the Colombia region is impacted due to COVID-19? And what solutions do you foresee from a legal perspective?
Well, that's a great question, very timely. COVID 19 has dramatically changed the legal sector in Colombia. Although prior to this pandemic, we already had some regulation as to digital operation of the judicial system, the truth is that it wasn't until COVID-19 that the government started to implementing the measures to apply cell laws regarding digital justice and issuing a few more to set in motion this system. Colombia has traditionally had an overloaded judicial system, which has lacked of the use of technology, and COVID-19 has been the best example of said problems. Since its arrival, most of the judicial system collapsed and stopped. This was critical as it meant that all of the litigious processes, except from some criminal matters, were completely motionless. However, the government issued new regulations that allow the resumption of the judicial system, and even though there are multiple aspects that require tremendous development, it is a start, and it is a start that all of the practicing attorneys have been waiting for over a decade. Therefore, although COVID brought problems such as the delay in processes, I think that the overall effect in the Colombian legal system has been great, as we wouldn't have faced a problem as big as this, we wouldn't have a digital system yet. Also, particularly as regards to the consumer protection law and competition law, we have experienced some changes too. Given the quarantine restrictions ordered by the government, the companies had put all their efforts in potentiating the e-commerce. According to a recent study, the e-commerce in Colombia has grown in 3 months, which was expected for the following 4 years. This, of course, has been really good, yet it also had brought some issues related to the asymmetry of the information and the fulfillment of the obligations that the product providers have with the consumers. Our authority has sanctioned multiple companies for breaching their duties for providing clear information and meeting the delivery times. In other cases, the authority has also sanctioned companies for establishing prices which exploit the consumers, especially regarding highly demanded goods in these times, such as masks. Thus, although COVID 19 has been and it is a really difficult situation for the world and our country, it has also played a starring role in the development of the digital judicial system and the e-commerce in Colombia. To the point that if back in February you have asked me about digital justice, I would have said that it's still a dream in Colombia. Now it is a reality.
What do you think will be the decision of the Supreme Court of the United States on the petition for a writ of certiorari submitted by Jack Daniels Property within the case of VIP Products LLC versus Jack Daniels Property?
Well, very good question. This definitely has been one of the most interesting cases in the last few years, and soon could have a radical turn given the writ of certiorari submitted by Jack Daniels Property Inc. As the majority of the viewers surely know, VIP Products released a dog toy which is similar to a bottle of the well-known Jack Daniels bottle. Instead of Jack Daniels Old Number 7, it's called Bad Spaniels the Old Number 2. This case disrupts not only the market, but the topic of conversation of every IP and competition attorney. At first, the district court determined that there was a likelihood of confusion between the dog toy and the trademarks and trade dress of Jack Daniels, and also a potential dilution by tarnishment. Yet, the Ninth Circuit diverged from some decision and determined that the likelihood of confusion test does not apply as the dog toy is expressive. Recently, Jack Daniels Property submitted a writ for certiorari, and if granted, the Supreme Court of the United States would determine whether the use of humor in this notorious dog toy indeed implies that the likelihood of confusion test does not apply. Um, well, regardless of how amusing I find the Bad Spaniels, for me it is quite simple. If this toy didn't evoke the Jack Daniels bottle and its well-known trade dress, it wouldn't be this famous or successful, and that is precisely one of the protections that a trademark grants you. When you register a trademark, and especially when you become well-known, you can exclusively use it and prevent others from copying you and or exploiting your reputation in their benefit. In other words, when you are buying a Bad Spaniels dog toy for your pet, your consumer decision is absolutely biased. Additional to its quality and price, the reason why you are buying it is because said toy reproduces the distinctive elements of Jack Daniels and reminds you of said liquor. And that is a right that only has the one who designed such original bottle, invested a lot of money in promoting it to the point that it is in the top of mind and protected through a trademark. Therefore, it is true that Bad Spaniel is certainly funny and one may say artistic, but it is also true that it is funny and is this famous because to the reproduction of distinctive type and recognition of Jack Daniels. For me, this clearly fits into a parasitic use of their trademarks and trade dress.
Perfect. So, have there been cases like this in Colombia?
Mm, well, in Colombia, it would be very difficult to find a case just like this, since our legislation does not contemplate humor or satire as an exception for using a trademark without its own authorization. Only until 2018, our legal system included the transformation of literary or artistic works for parody purposes as an exception. Yet, this does not apply for registered trademarks, and in any case, it would also be necessary that said transformation does not generate likelihood of confusion with the original work. Nevertheless, we have some experience with cases of unfair competition in which the reputation of one company was exploited by a third party. For instance, back in 2012, some entrepreneurs started to selling the famous beer of Homer Simpson, the Dove beer. This case was quite remarkable since their company became really important and relatively easy. You could find a Dove beer not in Springfield but in Bogota. Also, this case was well known because this company was able to obtain a trademark registration for their product by filing the nominative element of the trademark as DUH, D-U-H, instead of Dove. Yet the graphic design was the same than the famous beer. Despite of having a trademark registration and insisting their beer being called DUH beer, the Colombian Competition Authority granted the claim of 20th Century Fox Film Corporation and determined that said bidder used a name which was protected by copyright and industrial property rights, and its use exploited the reputation of the plaintiff. Another exploitation of others' reputation occurred when a local liquor company promoted their product, which is a national liquor called aguardiente, by using the expressions "Go Blues" and "Celebrate the Blue Goal." The competition authority considered that said expressions were allusive to Millonarios Football Club, which is the greatest football club in Colombia and is highly recognized for using the color blue in their uniforms. According to the authority, said use without a sponsorship agreement allowed the liquor company to strengthen the impact in the market and promote their sales, and hence it implied the exploitation of said football club reputation. And these kinds are really interesting. So I am eager to see what will happen with the Jack Daniel case. As regardless of the result, I'm sure it will leave great lessons for the ones like me who are really excited about the relation between humor and advertising, intellectual property, and competition.
Definitely. So we are also waiting for the results from the Supreme Court. And apart from that, on the personal front, I would like to ask you the three core values you truly believe in as a lawyer.
Okay, thank you. I think no doubts on this one. For me, it's passion, responsibility, and a winning mentality. I don't know anyone who is really good at something without being passionate about it. When there was late and everyone was sleeping, young Coltrane used to practice for hours his saxophone fingering technique just by moving his fingers without even blowing. For that, and of course his gift, he became one of the greatest musicians ever. Passion is what drives us to be better and accomplish our goals, and this is especially important when you are representing someone else's interest, which is exactly what lawyers do. Providing efficient solution to clients means to understand and care for their business at least as much as they do, since just offering legal strategies for overcoming a problem is a duty that belongs to multiple centuries ago. Our job as lawyers is to be an important, if not the most important, partner in the expansion of the client's business. For this purpose, you will be required to also follow very closely the news in the respective markets. When you are this committed, you can start providing clients with efficient and crucial advice. Secondly, you must be very, very responsible. Once again, you are representing someone else's interest and they and or their company are in your hands. So you must be as prepared as a human being can be. This means taking very seriously any situation or problem that your client might have. Regardless of how big it is, you must be as concerned as it was your own problem. And for this purpose, you will have to carefully analyze every single detail, as it is well known that the devil is in the details, and study any possible point of view and outcome and being prepared for it. This will also imply anticipate your counterparty moves and know their claim better than them. Now, if you add on top of that a winning mentality, there is no way you can lose. Of course, this is an hyperbole, and you can never guarantee to a client that you are going to win. But what you can guarantee is that you will put your best efforts, will prepare it as much as is necessary, so, and you will be so convinced of the rightfulness of their case that hopefully you will obtain a favorable result for their interest. So it doesn't matter whether your case is backed by 50 years of judicial decisions or if it's the first of its kind. You must trust in your work and trust so deeply that you certainly believe that you are going to win this one too.
Really, really insightful. And thank you so much, Felipe, for sharing such a great insights with us. And we look forward to have a chat with you again in the future on some other trending topics. And for our viewers, if you like this chat with Felipe, please like and share this video and subscribe to Clickway Creators YouTube channel. And appreciate what we do and have more coming from the industry leaders. This is Abhishek for LexTalk World.